Hey everyone, this is Elizabeth with Star Bay Realty, and today we're going to go over vacant land. Now, vacant land can have a lot of different uses. Sometimes buyers are just interested in purchasing vacant land as an investment. Sometimes they're planning to build on their property, their future home. They can be using it for commercial purposes or agriculture, or there could be other uses as well. Let's start out with the vacant land contract. Now, the contract that I'm using is the most recent revision of the contract provided by the FAR Bar. And you can see on here it's called the VAC 1111, and it was revised in June 2017. So the first page, you're going to go ahead and enter in the name of the seller and the name of the buyer. Now is a good time to double check with your buyer how they want to purchase a property. If they want to use their personal name or they want to purchase it under a trust they have or LLC. The reason I advise you to double check it right now is that sometimes agents have assumed that their buyer was buying the property under a personal name, and at the last minute they said no, it was supposed to be under our trust, and it can be difficult to change it at the last minute, especially when you're dealing with financing. Next, you're going to go ahead and enter in the address of the property and the legal description. Now, these items should automatically populate if you're using Transaction Desk or other transaction websites through the MLS. But even though they auto-populate, I would definitely double check, especially the legal description of the property. And a way you can do that is by going to your local county property appraiser website. In this example, I use the Hillsborough County Property Appraiser. And if you scroll down, somewhere on the page where the property information is located, you can find the legal description. And I would also double check the actual deed of the property, which is also public information and can be located on the county website too. It's good to have two identifiers just to double check that the legal description is correct. Next, you'll go ahead and enter the section, township, and range of the property. This can also be found on the county property website, and the folio number. And if there's any improvements on the property, you can include that as well if they're conveying, such in this example I just put a garage. Go ahead and enter in your purchase price of the property and the escrow agent information. And if there's going to be an initial deposit, you can go ahead and put that on here. So the default on here, and the same with the residential contracts, is 3 days. Even though it automatically defaults to 3 days, you could have left it blank, but I prefer never to leave any blanks or leave as few blanks as possible because it could lead to errors in the future. Somebody might accidentally fill it in later, and it's hard to determine which contract was the actual initial contract. So it's better to, whenever there's blanks, fill in what you can. And then the second deposit, typically, which would be after the end of the feasibility period, you can enter that in here. If there is financing, you can enter in the dollar amount, or you could just enter in the percentage, and the balance to close will automatically calculate for you. There's another option where if you don't want to purchase a property under a purchase price necessarily, you could do it on a unit per cost, which would be something like $30,000 per acre or a different amount. And you would get a surveyor to survey the property to find out the total area of the property. I don't really see that option used that often, but it is there. Next, go ahead and you put in your time for acceptance and closing date. Again, this is similar to any other residential contract. The closing date, you are going to need more time than you would with a residential contract, which we'll get into later. For this purpose, I put 4 months from now. Oftentimes, you'll see vacant land being purchased with cash, but sometimes you'll see also with financing as well. So just like the residential contract, you would go ahead and enter in the financing terms. Or if there's seller financing, enter those terms, or mortgage assumption. you would enter those terms. And as always with mortgage assumption or with seller financing, I would highly advise you to get a lawyer to draft up additional paperwork or amendments to this contract to specify the terms and liability and releases. There's an option to assign this contract. Once again, like I mentioned before, though, if the buyer's not sure what type of form that the buyer wants to purchase a property, this would allow them to give some time. They could select here, may assign but not be released from liability under this contract. However, be sure to push them to get that done ASAP, especially before the financing period is over, if there is one. Title. So here it says that the seller has the capacity to and will convey marketable title to the property by a choice of a specific type of deed. It's better to choose statutory warranty deed if possible, or you could choose special warranty deed if that's what the seller wants. If you need reference to the different types of deeds and their meanings, that would be a whole different chapter, which we can go into another time. Let's see here. If there are other items which the title will be subject to, you can go ahead and include that in here. Sometimes it could be an HOA or private access. Title evidence. This example will say that the buyer is going to pay for the title search, and within 30 days after the effective date, the title search and evidence should be provided to the buyer. After examining the title, the buyer will have 15 days in this example, but no later than obviously the closing date, to examine the title and give notice to the seller if there's any defects. The seller will then have to cure those defects. If the seller is unable to cure those defects, then they should give notice to the buyer, and the buyer will determine if they want to continue with the property or not. Next, it explains the survey. So if the seller does have a survey, they should provide that to the buyer. And while that is good material for the buyer to use, it doesn't protect the buyer, because the surveyor only has liability for the seller, because that's who paid for the survey. That's who technically owns that survey. So it is highly advisable for the buyer to get their own survey done, especially when you're dealing with land, but for any property it's always advisable. And what you will find on the survey is the layout of the land, if there's any natural barriers or any setbacks, any encroachments, the boundaries of the land, and other items that should be notated on the survey. It should be noted that the survey actually has two portions. One portion is the actual map of the layout of the land, and the other portion is the notes of the property. You need to make sure you have both portions. If you only have the layout of the land, that technically is not a survey. The survey has to include both portions. The notes will include any exceptions that are located on the property. That's why it's important to give the full title search to the surveyor once the survey is being done, because oftentimes you will find in the notes that the surveyor will put that the title search was not given to them, so they cannot give any reasonable, or they cannot be for sure of certain exceptions on the survey. Another thing to watch out for is to find out what the limited liability of the survey is. Sometimes the note will say that the limited liability of the survey is up to the value of the survey. So if the survey was only $500 or $600, the liability of the surveyor is only that amount, which wouldn't really make sense for when you're dealing with a high value property. So again, title search and survey go hand in hand. Next is the feasibility study. This is probably the most important part of the contract. When dealing with vacant land, you do want to make sure you get a feasibility study, and you want to get as much time as possible that the seller will give you. At least 90 days, I would say, for the feasibility study. Sometimes longer than that. 6 to 7 months is common, especially when you're dealing with rezoning and you need to speak with the government. Those things take time. So give yourself plenty of time for the feasibility period. There are numerous items that your buyer needs to check out when looking at the feasibility period of this. And oftentimes it involves getting professional advice. So it is highly, highly recommended that your buyer get a geotechnical study. In order to get this study done, you would need to find an engineer to do this. Your engineer will also be able to guide you on anything that they find during the study and any other studies that they would recommend or inspections, and they will advise you on professionals to seek advice from as well. You should also seek advice from a land developer to find out that the use of your property will be able to be rezoned, and find out if you will be able to use your property for the purpose that you would like to. You need to find information about wetland. You need to find information about zoning, setbacks. Talk to the neighbors. Talk to the county and city. Is there any eminent domain? These are only a few of the items, and you should make sure that your buyer is well prepared to find out all this information. And if they do need an extension of the feasibility study, definitely get that in before the feasibility study is over. If your buyer says that they do not want a feasibility study, I would definitely try to get that in writing as an affidavit or some sort of proof that you did, as a professional, advise your buyer to get a feasibility study, but they have decided not to. Okay, so the next page goes into government regulations, closing procedures, who pays for what, prorations, etc. Okay, computation of time. So this contract is in calendar days. So anytime you're dealing with time periods, it will be in calendar days. It will include Saturday and Sunday and any holidays. The only exception to that is if the time period is 5 days or less. And also another exception is if the time period ends on a Saturday, Sunday, or a holiday. In that case, the time period will automatically be extended to the next business day until 5 p.m. Okay, and if you keep going on here, notices. Okay, I think this part is important. Anytime you, the representative of either party, is given any type of notice from the other party, it is the same thing as the other party notifying your party. So anytime you receive any type of notice, make sure you let your buyer or your seller know right away so that they can fulfill their obligations to this contract. Default and dispute resolutions, it goes into how that will be proceeded with. Attorney's fees, escrow agent obligations, okay, and broker liability. So you, as a legal real estate agent, are supposed to advise your party to all the facts and representations that are important to them and consult them on appropriate professional, and also consult them with any information that you think they should know and advise them on any activities or duties that they should perform prior to engaging into this contract or during this contract. Another item about that though is that you do not want to go outside of your scope of practice. So while you do have a lot of knowledge from your background, if your party is asking for any type of legal advice or tax advice, you don't necessarily need to provide them that advice. You should seek them to the correct person to ask about that. So you can guide them to tell them, hey, you really should seek counsel, legal counsel on this situation, or you should seek an accountant, or you should seek a mortgage broker. And even if you do know the information, sometimes the information may be misinterpreted by you, which will lead you to have more liabilities. So you want to give the best advice you can, but also remember not to go out of your scope of practice. And at the end, it will show the commission portion. So the way the MLS technically works is that the listing party should be paid commission by the seller, or sometimes they could have the buyer pay a portion of that, and then that portion would be split by you and that listing party. So we'll go ahead and put that party A will be compensated by the seller, and party B will be compensated by the broker, which will be the commission split. The next page will have any additional terms that you want to include, and go ahead and have both buyer and seller sign. And if they're going to counter, if the seller decides to counter any of the items, make sure that both parties initial any things that are going to be countered on. And another thing I forgot to mention is during the feasibility period, you do want to get your vacant land disclosure. Sometimes the seller may say, well, you know, I obviously never lived there, I don't really know much about the property. Doesn't matter. You still want to get that disclosure. There are some notices that, you know, if they received anything, they should give that to you. And if you had that disclosure, that will help you in the future if there's any discrepancies of what they're saying and what is the actual truth. I hope this webinar was informative for you guys. If you guys have any other questions, please don't hesitate to reach out to me or our brokerage office staff. Thank you and have a great day.